our next item on the agenda. It's a preliminary hearing on a complaint by Joseph Cascino against Otto Swingler, which complaint alleges campaign finance violations, specifically, I think, 2-2-23 and 2-2-26. And will the parties please announce who is appearing before the commission? I want to make sure that the complainant and respondent are here and announce themselves accordingly.
This is Joseph Cascino, the complainant.
Hello, Mr. Cascino, and respondent, counsel for the respondent, is that you?
Yes, this is Eric Opiella for respondent, and also respondent is in attendance as well.
Great.
Swingler.
Okay. Hello, Mr. Swingler, and thank you, Mr. Opiella. Counsel for respondent, how do I pronounce your last name? I'm sorry.
Opiella.
Opiella.
That's okay. Everyone mispronounces it.
I've
been used to it for 43 years.
Yep, I've lived that life myself. Opiella, I appreciate that. Okay, well, I am happy to briefly go over the procedures in a preliminary hearing if you'd like. I believe that both complainant and respondent should have gotten a notice of the preliminary hearing that included the rules of procedure and kind of the parameters for how the presentations are going to go. I am happy to, if you didn't, I see some looks. I'm happy to do a quick overview of what's in store in a preliminary hearing. And a reminder to mute yourself if you're not talking, just so that we minimize feedback as much as possible. Commissioners, parties, everyone alike. So a preliminary hearing, the question before the commission is whether or not there are reasonable grounds to believe that a violation occurred. And if there are reasonable grounds to believe that a violation occurred, whether we go to a final hearing or if it's uncontested and the respondent admits that there was a violation, what the appropriate sanctions are. That is what happens at a preliminary hearing. Both the complainant and the respondent are allotted 10 minutes for a presentation. And at the end of that 10 minutes, commissioners, at the end of each 10-minute presentation, rather at the end of both 10-minute presentations, so complainant will have 10 minutes, respondent has 10 minutes, and then the commissioners are open to ask questions of each party. There's no cross-examination. If there are questions that you would like to pose to the other party, you can ask the commission, and the commission then in turn, if they think it's an appropriate question, can pose that to the opposing party, but there's no kind of cross-examination allowed. I don't know if, Lynn, I'm happy to have you jump in if I'm missing a kind of important key thing just for the sake of everyone's understanding, but that's kind of the gist of it. Anything to add? Uh-huh.
Sure. Lynn Carter, attorney for the commission. I will just add that the commission has the option of, if there is an admission, there's essentially no contest about the violations. The commission could determine sanctions at the preliminary hearing, or it could choose to proceed to a final hearing. It has both those options.
Right. Okay. Then Secretary Lerner is going to be keeping time for us. She'll, I think, as she was doing at the beginning of the meeting, hints 10 minutes, yes. And so she'll let you know when I think we're getting close, or yeah, that's how we usually do it.
I don't want to interrupt y'all. So you're going to see the clock, and so I just ask you to try to watch. If not, once you take a break after the 10 minutes ends, I'll try to let you know that your time is up.
Yeah, and we'll let you finish your thought or your sentence, but we'll try to keep it to 10 as best we can. Okay. So whenever you are ready, Mr. Cascino, as the complainant, you'll have 10 minutes, and whenever you're ready, you can start.
Wonderful. Thank you, Mr. Chair, members. My name is Joe Cascino, and I'm a student at the University of Texas, and I'm active in local campaigns. I won't need all 10 minutes, nor do I have any sort of fancy PowerPoint, but I'm very appreciative of the opportunity to roadmap my complaints. Back in late March, a friend of mine sent me a screenshot of a gentleman named Walt Ferguson's Facebook post soliciting funds for a pro-Prop B billboard campaign. After actually going to the link, I saw that there was a fundraising campaign connected to a city election that was organized by Mr. Swingler, as well as a John Henry Swingler and a Kendall Brown. After actually going to the link, I saw that there was a fundraising campaign connected to a city election, organized by these three gentlemen. And at the time that I checked, it had raised over $25,000 out of a $30,000 goal. There was no disclosure statement of any kind, and some of the donations were listed as anonymous, which not only violates sections two sections in Chapter 2-2 of the City Code, specifically Chapter 2-2-32 and 33, because of the lack of disclosure and its anonymous sources, as well as 23 and 26 due to the apparent lack of a treasurer's report filed for something connected to a city election. It also violates Chapter 252 of the State Election Code. I might be young, but I know that the very first thing anyone must do in any campaign or in any PAC of any kind is to file a treasurer's report. It's not only in the city code, but it's straight up state law. To my knowledge, Mr. Swingler has no PAC registered with the city clerk or with the Texas Ethics Commission. Additionally, I don't know if Mr. Ferguson, the gentleman who posted the link that kind of tipped me off to this, was acting in a private capacity or was himself connected to the group pushing these billboards. But if he was connected, he was simultaneously soliciting funds for Save Austin Now PAC in the Facebook post in question, which, absent a sworn statement as required by Chapter 2-2-32 subsection B, is a violation on his part. Upon looking back at the GoFundMe several days later, the fundraiser had been, quote, deactivated by the organizer, but said that it had raised its $30,000 goal. While I have a screenshot of the deactivated fundraiser stating it had reached its goal and that the $30,000 had been raised, I regretfully did not take one while the fundraiser was still active, showing these anonymous donations and the lack of disclosure. As mentioned, all of that previous information was hidden now. So nonetheless, though, if you Google Mr. Swingler's original GoFundMe link today, clicking on it is a 404 error, but it still reads in the description on Google, quote, I have spent $10,000 of my own money creating artwork and printing vinyl for blank, and then it ends. Though the original fundraiser has been deactivated, in my view, it is within the public interest for open knowledge of where the raised $30,000 went and who provided it. I understand that this committee has the power to alter complaints to better fit other sections of the code, and it seems that my complaint has been changed to sections 2-2-23 and 2-2-26. That's completely fine with me. I'm not by any means an expert, but I do know that in accordance with Austin's model campaign finance rules, the actions by Mr. Swingler warrant looking into by this body, and I'd be happy to send over whatever screenshots or supplemental information I have and answer any and all questions. I'll cut it off there. Thank you.
Thank you, Mr. Cascino. I want to just very briefly clarify something. I had actually made an error in describing the alleged violations. The commission doesn't have the power to kind of tailor complaints to different code violations. So the original chapters, sections of city code that you had initially indicated in your complaint, that's the complaint before us. So I apologize if respondent was confused by that either. Misstatement on my part as to which city code provisions we're talking about. It's those that were in the complaint that you filed. So, okay, with that, thank you very much, Mr. Cascino. We'll go to respondent now for 10 minutes. Counsel, for the respondent, are you going to be speaking for the 10 minutes or is this?
Yes, and give me one moment. It probably won't be the entire 10-minute period. We do have a PowerPoint to share. Can y'all see that?
We can, yes.
Okay. Great. Well, thank you so much for hearing our response and our reasons for dismissing the complaint against Mr. Swingler. that was raised by Mr. Cascino. As the chair noted, the agenda for the meeting tonight did not state the actual reasons correctly for the complaint or the city code's provisions that were alleged to be violated. However, the notice that we received did correct from Ms. Lynn Carter, who's your counsel, did correctly state those. So that's something that y'all will have to work on and decide whether proper notice was given for this meeting, because it did not note the actual provisions that were raised in the public notice that was given for this meeting. But nevertheless, I'm going to go through the specifics of the complaint, and we'll start first of all with the first alleged violation. I don't know if you have a copy of the complaint in front of you. You all should have been provided a copy of that complaint. But the first allegation is, as Mr. Cascino mentioned, that the GoFundMe solicitation did not have the disclaimer required by Section 2-2-33 of the City Code. First of all, I will note that we will show that GoFundMe did not charge for this page. If you're not familiar with the GoFundMe system, it is a web-based system that allows people at no charge to post needs that they have for fundraising purposes. And those funds are then become the property of the person who is raising those funds. There is no charge by the website for the solicitation. And he mentioned this Facebook post that was made by Mr. Ferguson. It first was not made by the respondent, and so he had no knowledge or involvement in the post. But it also was without charge. As you well know, Facebook does not charge for posts. In sum here, no person made any political contributions to Respondent in excess of $500 to fund the GoFundMe solicitation page because it had no charge. Therefore, the $500 expenditure limit that is in 2-2-33 was not reached, and no disclaimer was required for that page. And you'll note in 2-2-33 sub D, it does not apply to items that cost less than $500. Moving on to the second alleged violation. And this was the first allegation regarding 2-2-32, which deals with direct expenditures. And I'll first note his allegation was that some contributions were anonymous. First, I will note that 2-2-32 only applies to direct expenditures, and there was no direct expenditure that was made to benefit any ballot proposition that was there. It was, in fact, the funds that were collected were contributed to Save Austin Now. The plan originally by Mr. Swingler was to engage in a billboard campaign, but once he realized he could not effectively do so in compliance with the law, he then donated those funds, which Save Austin Now reported, and never made a direct expenditure. But nevertheless, no contributions were anonymous. While the page itself allows donors to designate whether their name shows up on the page, all donor names were provided to the fundraiser, to Respondent. And even though he was not required to do so under city code, he provided the names of his contributors to Save Austin Now PAC upon the advice of counsel after he engaged counsel. And so I do understand that Save Austin Now is in the process of amending their report to disclose those to the public, but he did fulfill any obligations he would have under state law. And of course, there were no obligations under the city code that is enforceable by the Austin Ethics Commission to provide those names of those contributors. But he did so in any case. So I want to talk about direct campaign expenditures and what the definition of that is. A direct campaign expenditure is defined in 2-2-31, and it is an electioneering communication that is made without the prior consent, cooperation, strategic communication, or consultation between a candidate or a person or entity making that expenditure and without any sharing of material information. In this case, he didn't make any direct expenditures. He merely posted a fundraising campaign, realized that he couldn't actually conduct that campaign, and then in good faith donated those funds to Save Austin Now, who engaged in whatever activities that they engaged in with the funds that they raised for their ballot proposition campaign. So, in sum, there were no requirements on Mr. Swingler to report direct campaign expenditures. He also did not form a political action committee, and I'll get into that in just a moment. Just a quick aside on GoFundMe. GoFundMe donations are the personal property of the respondent. They were not actually. If you look at how the platform is set up, once they're received, they are the personal property of the recipient. They're considered gifts for federal income tax purposes, as it states on the GoFundMe site, unless they're accepted in exchange for goods or services, in which case, they were not. They also were properly reported as a contribution by the respondent to Save Austin Now PAC when they made them. He referenced, the complainant referenced this team that was set up when he set up the fundraiser. However, Mr. Swingler did not seek any approval or was not required to either by GoFundMe or interaction by the team members. He didn't notify them prior to naming them as team members, nor did he obtain any consent to do so. He merely named his relatives, and that's who was listed, in the event he was unable to proceed with the fundraiser due to any unforeseen circumstances. And in no way he did work in concert with them or they with him, which is fundamental to the definition under state law, even though the city code doesn't define what a political committee is. And so the short answer for GoFundMe, that you use this site to raise money for any cause that you would want. It's not a political fundraising site. You can raise money for a charity. You can raise money for any expenses that you have. And the terms of that website state explicitly that they become the personal property of the respondent. And so he then reported what he knew to Save Austin Now PAC, and then later also fulfilled any additional obligations he might have under state law by disclosing those names and amounts and dates of contributions to the recipient PAC. His final violation that Mr. Cascino alleges is another allegation regarding 2-2-32. Well, first of all, he said that a sworn statement of non-coordination was required by Mr. Ferguson. Well, first of all, Mr. Ferguson had no cooperation with Mr. Swingler. Respondent did not solicit that Facebook post by Mr. Ferguson and had no involvement in it. And so there was no statement of non-coordination required, first of all, because there was no direct expenditure. This deals with the direct expenditure section. Respondent, as we stated earlier, raised funds as an individual, set up this campaign, and then donated those funds once he was not able to execute on that campaign. And then in particular with regard to the commission rules, this last allegation does not follow your commission rules for a valid complaint because it does not specify a date of the alleged violation. And your commission rules 1B1 specifically state that you cannot consider a complaint that does not allege a specific date of a violation. He did not allege a violation of 2-2-26, but I will mention specifically with regard to 2-2-26 that he is not a candidate, he is not an office holder, he is also not a political committee because state law requires, in definition, that a political committee is two or more persons acting in concert with the principal purpose of accepting political contributions or making political expenditures. And it does not include a group comprised of exclusively of 2 or more individual persons as well. And so he raised money for an effort. Go ahead. Are we at time?
Yeah, your time is up. You could just go through.
We're open for any questions. I want to, before we leave the presentation, we are required to notice if we do go to a formal hearing, the witnesses that we notice to be called, and that would be Mr. Swingler, Mr. Ferguson, Mr. Swingler's brother, and also Kendall Brown. We're open for questions.
Well, thank you very much, Mr. Opiella. So with that, commissioners, I am happy to open the floor to any of your questions for either complainant or respondent. And I see Commissioner Greenberg's hand first. So go ahead, Commissioner Greenberg.
I have questions for both. The first is for the complainant. So are you not making a complaint about the fact that the billboards themselves had no disclosure on them?
No, ma'am. I just saw these on the GoFundMe for a billboard campaign, but this is not related to what was on the billboards themselves.
Okay. All right. And then for the respondent, did Mr. Swingler donate $30,000?
Did I donate the money to Save Austin Now?
Yeah, did you collect $30,000 and then $8,000 in your own name?
So all the money that was raised on GoFundMe, we donated the entirety to Save Austin Now PAC in an effort to follow, the Political Action Committee laws. So we didn't contract for billboards on paper.
Consistent with the GoFundMe being the property of the people who collected it, were those donations in own name?
So sorry, it just cut out a tad. Do you mind repeating the question?
Yeah. So your lawyer said that the GoFundMe contributions are the personal property of whoever collected that.
Sure.
So was that a contribution? Was all the money contributed in your name?
All the money was
from the GoFundMe
in my name to Save Austin Now PAC, and then in addition to my name being listed as a contributor, we listed all the names of anybody who gave me money. We honestly a pretty complicated set of rules for all of this, and so we tried to provide all the names and dates and amounts of anybody who donated to the GoFundMe, including, by the way, specifically the anonymous. That's just anonymous for
posting on
page.
Yeah.
So I could see it, and so I had a record of everything. By the way, it was 101 or 102 people. Some of these donations were as small as $10, $25. As large as $200 or $300. Obviously 90,000 people showed up in our city to vote for Prop B, and I think the overwhelming support you saw at the polls was seen. When we raised money for this effort. I think being an Austinite, born and raised my whole life here, going to Austin High School and University of Texas, same as Joe. We and anybody else I think who turned out to vote, regardless of which way they voted, cared about the outcome of this election.
Yeah, I'm not asking about all that.
Sure.
I think you've already answered my question. Thank you.
Commissioner Kale, go ahead.
Yeah, I have a question for Mr. Swingler. When did you, a couple of times I've heard the terminology from your counsel that you realized you wouldn't reach the goal of raising the money for your billboard effort. At what point did you realize that and decide to donate to Save Austin Now instead?
Oh, I think he was referring to the following of the rules for political action committees. We actually had overwhelmingly positive response on the GoFundMe page. And I was frankly shocked that we raised that much money. I think it was just an issue that people cared a lot about and were willing to donate. 30 grand was raised in, I think, 72 hours. I didn't expect to raise that much money by any means, just kind of planning to send it to a few people that might share the same, concern for our city that I did. And thankful obviously for their donations, but I think what Eric Opiello was referring to was the ability to execute on the billboards was something that we thought, hey, I think, kind of in the middle of raising this money, I had somebody tell me, hey, I think you should donate this to a PAC in order to make sure you follow the rules. The PAC had, paid for by Save Austin Now PAC on all the billboards, including the top 5 donors of Save Austin Now, just like the signs are supposed to say. So the intention, despite now ending up on this Zoom call, the intention was, in fact, actually to follow all the rules. We raised money in an effort, to make people aware of a local election that, historically speaking, has very low voter turnout. The goal is, hey, if you care about this issue, go vote. Initially I had planned to contract for the billboards myself, did not end up doing that. Save Austin Now contracted for the billboards and, put the disclosure statements, paid for advertising on the billboards themselves.
I guess I'm asking, at what point in that process did you pivot to donating the money to Save Austin Now instead of deciding to do your contract for your own billboards?
Oh, at what point in the process?
Yeah.
I mean, we raised that money within a 3 or 4 day, time frame from 100 people donated. And that was, within a few days, donated to, kind of as soon as we closed the GoFundMe, it was done. We donated it to the PAC.
Okay, thank you.
Sure.
Commissioner Danberg?
If we do go to a final hearing on this, because this has been, kind of an ongoing issue before the commission, my understanding is that at a date certain, Save Austin Now went from being a 501c organization to being a PAC. And so if this goes forward, I would like to ask both the complainant and the respondent to provide for us a calendar, more or less, of on what dates this happened, on what dates that happened, so that we can get it straight in our heads as to that transition from being a 501 educational organization to being a PAC.
Deborah, just to make sure I understand your question, because Joe and myself, I don't think either of us have any involvement in Save Austin Now. Are you just talking about my GoFundMe, billboard campaign dates?
Right. I'm just trying to figure out the degree to which on this date or that date you were in your mind, or in fact, in law, donating to a 501c educational charitable group versus donating to a PAC.
I do know the dates in which, prior to myself starting the GoFundMe, Save Austin Now had already converted to a PAC because I had donated to it prior to starting. Actually, all the work that I was so impressed by that they were doing, I actually, that's part of what motivated me to make the GoFundMe, frankly, was, oh man, we need to continue to raise awareness about this. So it definitely was a PAC by that time.
And Commissioner, just so I can clarify as well, do you need any sort of timeline for me? I mean, really, it was just like I saw I saw this, I think, March 25th for the first time. I think I filed the complaint April 2nd. I could be wrong. There could have been a different date, but something like that. I don't have the complaint in front of me.
Yeah, I appreciate both of y'all's candidness on this. As I say, if we do go forward, I do want to actually get y'all to both check dates, and then we'll check it against the actual formal records.
Sure. I will note, even though we obviously do not think that there was a violation that occurred by Respondent, he's more than happy to provide the dates when he started the campaign. I believe he did by recollection there, and I understand. I just looked it up that the PAC was formed in February of this year. So,
okay.
Just trying to be useful.
Commissioner Kale, go ahead.
Yeah, Mr. Swingler, so can you clarify for me how you found out that to comply with the rules you needed to donate it to Save Austin Now instead of putting it toward billboards?
Yeah, just one of my contributors said, "Hey, you should look into this. The rules around, the rules around political advertising are, very complicated." And, I thought it was as simple as, "Hey, I want to pay for a sign." And apparently, if you spend more than $500 personally, I think you have to form a PAC. Because we had raised, money for, I think, 17 or 18 billboards at the time. Somebody had said, "Hey, you might want to look into the rules around this." I thought, "Hey, I'll call the Save Austin Now people." They clearly have this set up. It says PAC at the end of their, wording. And they were happy to receive the donations, loved the idea, contracted for the billboards. I thought I was frankly doing everything as much on the up and up as possible. And all the billboards did state, political advertising paid for by Save Austin Now, somebody else's name. And I think a few of the top donors to Save Austin Now's name. So in my mind, when I got this complaint, I was kind of like, man, how did I not follow the rules? Like I was about to not, I thought, and then I thought I went to great lengths in order to, I'm not involved in politics. I have really no interest in it. Just lived here my whole life and wanted to try to raise awareness about a vote that I thought was important. Kind of the extent of it.
Okay, thank you.
I have a question for the complainant.
Yeah, go ahead.
Mr. Is it Cascino? Is that how it's pronounced?
Yes, sir, like Vegas.
Okay. Do you still contend that the identities of the donors are hidden from public view?
Yes, and that is because two reasons. One, so they were anonymous, and there were some anonymous listed at the time, and whether or not that was through GoFundMe's kind of system, that was the case. And then secondly, the website has been taken down. And so, the fundraiser ended, and that had kind of closed by the first week of April. And so,
I'm sorry to interrupt, but
yes, sir.
What we've heard from the respondent, from the attorney and the respondent himself, is that all those names have been disclosed in filings. Do you disagree with that?
That is confirmed.
Well, yes, sir. And even if that is the case, right, even if, as they've mentioned, they sent the donations and names to Save Austin.
I'm happy to hear your even if, but first I want to know if you agree that the identities of those donors is now a matter of public record.
Sure, but if it's been reported, but the money should have been returned to the donors nonetheless. And I mean, even
that's not your complaint, though, is it, sir?
No, but I'm just commenting on what you stated to me. And I would also add that even if the GoFundMe isn't a political fundraising site, right, and even if those funds become Mr. Swingler's personal property, I believe that even exceeds contribution limits. So,
you don't believe what exceeds Mr. Swingler's contribution to the Save Austin Now PAC?
Well, yes. If it's argued that is his personal property, then yes, I would believe that exceeds contribution limits. And
but again, that's not your complaint here.
I know,
the commission, correct?
I'm just saying.
Well, we can't really consider complaints that you haven't brought.
All right.
Okay. I just want to make sure I understand what you're claiming.
Commissioner Lovins, if I might correct a couple of issues. First of all, there are no limits with regard to measures. And also, I want to also note that we did provide those to Save Austin Now, and I don't believe that they have filed an amended report as of right now. They are working to try to add those to their report, and they have not done that yet. I want to make sure that the record's clear.
Thank you.
Yeah, and to add to that, just to be crystal clear, 102 names, 102 addresses, 102 dates, and 102 amounts. In addition to the 6 hours of Zoom calls, I've spent many hours, compiling all that, and so it's definitely accurate, and they certainly have a copy of it. So there's no missing data. But Mr. Swingler did fulfill his obligation to. So which actually doesn't exist under city code, by the way, as well, which is what this commission hears.
I want to thank the parties real quick and just remind parties to respond to the questions that are asked, and not to kind of if a question is not asked of respondent or complainant, the opposite party shouldn't chime in on their own accord. They should wait to hear a question from a commissioner. Just want to make sure that we're not getting into cross-examination or direct examination territory in the preliminary hearing. But Commissioner Levins, if you had further questions, I didn't want to interrupt you.
Oh, no, I think I have asked all my questions for now. Thank you.
Okay. Commissioner Stanton, go ahead.
Yes, thank you. Mr. Opiella, I have a question for you. You had mentioned that one of the reasons supporting your recommendation to dismiss this case was that it violated the commission's code, I guess, or bylaw, perhaps section 1B1 regarding requirement for the complaint requirements, that it had to have a date.
Yes, and that was only with regard to the third allegation, which did not allege a date. The other ones did.
Okay, thank you for that clarification. All right, but is it that allegation is all three of those allegations reside on one complaint, correct? And so the way I understand this, and maybe this is a question for chair or someone on the commission to clarify for me, is the date that is mentioned as the complaint requirement is the date. Is there cause, I guess is what I'm asking. If there are three allegations and one allegation does not have a date, does that necessarily violate our code?
So I'll let Lynn correct me if I misstate, as is always the case. Lynn, you are always welcome to interrupt me and tell me why I'm wrong. But I think that's a question for the commission to consider. I think the argument's been made that there is a commission rule that says that each complaint needs to have dates. And it's something that we can factor into our deliberation on this.
Okay.
But I think I can point you to the rule itself if you'd like to kind of follow along.
I have it in front of me, and okay. That's why I wanted to ask. Is this not, and let me know, Chair, if this is not the appropriate time for me to ask a question procedure-wise that neither Mr. Opiella or Mr. Cascino can answer to.
Sure.
Should I hold?
Oh, no, by all means, ask away. This is our chance. This is our Q&A period that's supposed to be kind of directed at the parties, but if you have a kind of clarifying procedural question, you can ask me, ask our outside counsel, Lynn Carter. Perfectly appropriate.
Thank you. I do have one more, if I may continue.
Mm-hmm.
Okay. I have one more question, procedural, which is, I think it was both Mr. Cascino and Mr. Opiella had mentioned that the meeting notice had referenced incorrect information regarding this complaint.
Mm-hmm.
And my question is, what what impact does an incorrect meeting notice have on how we can proceed with business and voting and deciding? In other words, if the meeting notice is incorrect, does it nullify? Are we supposed to wait to deliberate and to discuss this case until that meeting notice is either corrected or resent out with correct information, and then we continue?
So I think it's a fair question, a fair procedural question. I'll make a clarification in that I think that the notice letter that was sent to the parties had the correct violation cited, but the agenda that was posted for this meeting did not have the correct code violations. And I think that's the argument that counsel for the respondent was making as to what the effect of that is. That's kind of another thing for the commission to consider in its deliberations, but I'll let Lynn chime in if you have anything to add there. I'm happy to kind of give 2 cents, but I want to kind of give all the room for commissioners to ask questions of the parties while we have the chance. But Lynn, anything to add to that?
Sure. So the parties received proper notice through their preliminary hearing notices that has the proper code sections cited. The agenda had incorrect code sections cited, but it included the names of the parties, the date of the complaint, and so I don't have concerns about the subject matter meeting the open meeting requirements for notice.
Sure. And separately, do we? I may hold off and wait till we're kind of done with Q&A. I don't want to trample on any commissioners' questions. So I'm going to just leave the floor open for a little bit longer. Commissioners, any other questions of the parties or counsel? Okay. I'm seeing and hearing none, which means that we kind of open the door to motions or discussion on the item generally. So floor is open, commissioners, if anyone wants to discuss or is so inclined to make a motion.
I first have a procedural question, if I may. So we have one document, but there are 3 complaints. I assume that we can vote differently on the 3 complaints. We could say proceed to final hearing on one and not the other 2, or any mixture of that. Am I correct in that understanding?
Yeah, and in the past we have kind of gone ahead on with like one motion to say that there are reasonable grounds to believe that a violation has occurred, and then in the final hearing stage kind of differentiate which one is good or bad, is a violation, not a violation. And separately, we've kind of done split motions at the preliminary hearing stage as well at times, where we wanted to say that there were reasonable grounds to believe that a violation under this section occurred, but not this section. So the final hearing is going to be just about this one, not this one.
Thank you.
Yeah.
Oh, is this what you wanted? Yeah.
All right. A reminder to mute your microphones if you're not talking, but any other questions or discussion, commissioners? I'll make a kind of brief and maybe minor point, which is as far as the meeting agenda being incorrect, I don't know if that rises to the level of a kind of substantive error that would mean that we have to throw out the complaint altogether. If anything, if it were an appropriate violation for us to consider and think about, or an error that was sufficient to cause us to stop doing what we're doing right now, then I think maybe the appropriate remedy would be to postpone. But even then, I'm not sure that we as a commission, that's alleging a violation of the Texas Open Meetings Act in a sense, or it's an error that it's occurring under the requirements of the Texas Open Meetings Act. And I don't know that it's really for us to adjudicate unless it's a really obvious and blatant error that, like if we had the completely wrong names for the parties, and so the parties themselves, like no one knew who was going to be before the commission doing what. But that's my thought on that question. So, because I think the options before us right now, as a reminder, are if we wanted to, we could say we postpone this. And the pitfalls of postponing are that it is only those members who are present here right now that can participate in the hearing next time. So that's something we've discussed in prior hearings, but that's one option. Another option is to say that the violation has occurred and proceed to a final hearing. I'm just kind of doing this for the sake of our new commissioners, just if the parties are curious as to why I'm walking through this right now. Proceed to a final hearing because there are reasonable grounds to believe that a violation has occurred. And we don't even have to quite specify which of the allegations in that motion is the thing. We can go to the final hearing and decide then. And then we can also kind of split up the complaint if it has multiple allegations and go to a final hearing on this one or that one. And then separately, we can dismiss on its own motion to say that there are not reasonable grounds to believe that a violation has occurred. And there's one other option as well, which is, I think, functionally the same thing as a dismissal, but it's a dismissal because the complaint itself was kind of incorrect and gives the complainant an opportunity to correct the complaint. But even if we were to dismiss the complaint kind of outright, wouldn't stop, I don't think, the complaint. We had this discussion last time too. Wouldn't stop the complainant from submitting a new complaint, alleging different violations. So if that was word salad, I apologize, but the floor is still open for further discussion and possible motions if you have them. Secretary Lerner, go ahead.
I am embarrassed to this, but I would like to just re-clarify some facts, if y'all don't mind. It is hard for us to do all this stuff in a virtual environment because I have like all kinds of things open here, my book, the complaint, the agenda, like everything. So I apologize. Very basic for both the complainant and the respondent. So the allegation is that the billboard did not disclose this. What I wasn't really sure. Did the billboard itself disclose the PAC, Save Austin Now, on the billboard?
Yes, ma'am.
It did. Okay. And the top 5 funders for the billboard?
The Save Austin Now PAC, who contracted for the billboards, listed the treasurer and the 5 top donors on the billboard, so they were printed. Okay.
Now, when you raised money when your GoFundMe, and you turned that over to Save Austin Now PAC, so this is for the complainant. Is the complainant alleging? Are you still here? Thank you. Okay, Joe. Are you alleging that every single individual donor should have been listed?
No, ma'am, not on the billboards. My complaint is
no. I'm so sorry. Not on the billboard, but that should have been disclosed.
Yes, ma'am.
Okay, but did you agree though that what is your position on the threshold of $500?
Well, I mean, my issue is that, they claim to have turned over the names to Save Austin Now, which might be true, but I don't, as they've stated, it's not been reported yet. And so, I don't know, the $500 threshold, there were violations, I believe, since that, there's even in the description it read that, he had spent $10,000 of his own money. So,
Mr. Swingler?
I believe, but that's still a description that's publicly available, and I can send a screenshot of in any sort of supplemental hearings.
Okay. Mr. Swingler, did you want to say something?
I was going to ask Mr. Swindler specifically if he contributed to the GoFundMe himself.
Yes, I did.
Are you comfortable sharing the amount that you donated to the GoFundMe?
Yeah, if y'all would prefer, I have the spreadsheet that I sent with all the names and all the amounts. I guess I'd ask for Eric's opinion on this, but I'd be more than happy to just share it with y'all right now in real time, because that seems to be something we're talking about a lot, and I have the list in an email. I can just pull it up and show everybody.
Well,
I mean, it's public. It was provided to Save Austin Now, and if it isn't already public information, it will be, I'm sure, whenever they get around to amending their report. So they have, I believe, 14 days or something to that effect to do that. So
sure. Well, if you're not comfortable sharing how much you yourself donated to Mr. Swingler, that's fine. The reason I'm curious, and I want to thank Secretary Lerner for mentioning the $500 threshold. Is just, how about this? Was it more than $500?
Just to be clear, I donated numerous times to Save Austin Now PAC, and each time was well in excess of $500.
Sure. So specifically to the GoFundMe, if you put more than $500 of your own money into your GoFundMe.
Oh, no, I donated directly to Save Austin Now. I did never contribute. There was no real need. I mean, I would essentially be donating to myself from recollection. So I definitely donated to Save Austin Now PAC, not to my own GoFundMe. That money all came to my own checking account.
Right.
So it was all,
you didn't put money into the GoFundMe to move the bar or anything like that.
No, I'd have to go. It'd be on my spreadsheet if I did. Quite frankly, I can't remember because I've donated a few times to Save Austin Now. So does that, I guess I'm curious of the question though, does that, I mean, whether I did or didn't, does that matter for I'm just curious how that applies to this.
Well, so no, it's a fair question. Part of the, one of the thresholds is that you spend $500 or more in doing electioneering communications, and I think that was one of the. I think that was one of the violations. I could be.
Oh, there's no money spent on election communications. GoFundMe is free, Facebook is free. If anything, I would have contributed to the same cause, right? I think that was what Eric was trying to make the point out is we spent zero money advertising anything.
Right.
The GoFundMe page was completely free. I guess, Eric, maybe correct me if I'm wrong. My understanding was that the amounts were for paying for advertising. We paid for zero advertising.
The threshold is for an expenditure for a direct expenditure, and there was no expenditure made by Mr. Swingler or anybody.
There's no expenses. No person was paid. No company was paid. I think. I guess I was just wanting to clarify. I think my understanding is we had addressed that issue because we didn't spend any money. We just raised money without spending any money. So there was no political advertising paid for by disclosure needed because we didn't spend anything.
Sure. It was just, I think, a useful data point in kind of evaluating whether or not it's worth going to a final hearing, which is kind of the whole point of the preliminary hearing. Do you have the spreadsheet in front of you?
I happily pull it up. Yeah.
I wanted to finish my questions.
Oh, I'm so sorry, Secretary Lerner. Yeah, go ahead. Finish your question first.
Take a pin in that for a sec, and then you can load up the spreadsheet. It is your position, Respondent, that this complaint should be made against Save Austin Now and not against yourselves. Is that correct?
No, not really at all. I think we took all the. The whole point of me donating the money to Save Austin Now was just to make sure we followed the rules. I think Save Austin Now contracted for the billboards, paid for them, put all the correct disclosure statements on the billboards. To the extent that they got the wording wrong or something, maybe ask them about that. But I assume that they got that right. I think that my understanding of all of this is that maybe Joe thought that I raised all this money and contracted for these billboards, which I didn't do. In order to follow these rules, back in March or April, whenever it was, I donated all the money to Save Austin Now. They have, proof of that. That has been disclosed for months, or at least a couple of months.
when you donated that, it was for whatever purpose for them?
When I donated the money, yeah, I certainly talked to them about, what I was like planning to do, and was trying to follow all the rules to give them money. But yeah, certainly they could have spent it on whatever they wanted. And
so, but at this point, I mean, Mr. Opiela, this is I'm sensing that you feel as though this commission should be waiting to see that the information will show up in Save Austin Now's financial disclosures.
Yes, what Mr. Swingler did not violate any of the Austin City codes that were alleged to have been violated by Mr. Cascino. And so to the extent that he's alleging any violations, they're not by Mr. Swingler at all. And so he's met his obligations under the law. And I don't have any issue with, these are going to be public if they're not already. If this commission wants to review the names and the amounts, I do have the spreadsheet that if that will help the commission feel comfortable that he didn't violate the law, we're happy to share it at this time.
All right, thank you.
Commissioner Greenberg, then Commissioner Stanton.
I believe she's muted.
Reminder to unmute yourself. Thanks.
When did the respondent provide the list of names was it at the same time as the donation? And you mentioned they have 14 days, and I was wondering 14 days from when?
Yeah, so when he made the donation, because of the terms of, like I explained, of GoFundMe, he made those contributions from his own funds. And so he disclosed his name as the donor. Yes. After he hired me as his counsel, I advised him that even though the city code does not require it, it's probably in his best interest to disclose those names to Save Austin Now PAC, and he did so. I'm going to look up the. There was kind of a back and forth where he disclosed them, and then they said, "Well, we need more information from you." I believe that the first. We had this conversation the day I was hired, right before the last hearing that was postponed, and I believe it was around 14 business days ago. Let me look at the email real quick. When they finally got all of the information that they needed to be able to do that was May 24th was the last. The last email that was sent that had all of the information that they believed that they needed to file it. But
So well after the election.
Absolutely, because he contributed those funds from his own funds. And he was not aware of any, and he didn't, in fact, not only wasn't aware, he didn't have an obligation to disclose those names. But I told him that it would be advisable to do so out of the interest of public disclosure, even though the city code does not require it.
Yeah, and just to be clear, like my name was listed publicly as the donor of that $30,000 in 3 different pieces. So that is in Save Austin Now's, inventory. I had thought that we were following the rules because my name is disclosed with the amounts of money and all that. And, Eric had mentioned, hey, just put all the names in the public database too, because there's no reason not to. And everybody on that list had already donated to Save Austin Now anyway, so it's kind of like, let's just update the amounts. So that was the intention, was to go back and kind of make sure, hey, we're making sure we're following any rules or any issues that anybody would have. Let's make sure we've disclosed everything we've got,
Yes.
Commissioner Stanton?
Mr. Swingler, I apologize if I missed your response to the question. I'm still not clear. Did you donate any amount of money to the GoFundMe campaign?
To my own GoFundMe?
To the GoFundMe, not the amount that you gave to Save Austin Now, to the GoFundMe that is named specifically in the complaint.
I would have to check the spreadsheet. I think I may have done like the initial.
I'm sorry, what?
Mr. Swingler, your audio cut out just a little bit, and I think you're muted now.
It'll be in the spreadsheet. I'm happy to show that. But there's typically you have to make like a initial donation. I don't know if that was exactly what that was. This is back in March, so but I've got a record of everything.
Okay, I'm sorry. Your audio had cut off, Mr. Swingler, so I didn't hear your response. So did you contribute to the GoFundMe campaign that is named specifically in this complaint?
I believe so. I just don't know the amount off the top of my head.
Okay, so the answer is yes. My next question, and I don't know, this is probably more of a legal question, Chair. I don't know whom to ask this of, but this is very important to this complaint because it has to do with definitions, right? Mr. Opiella made a case again for dismissal, citing that that the codes are related specifically to direct campaign expenditure, and saying that since no funds were expended for this because GoFundMe is free of charge. And I thought it was clear at that point for me in my mind about the code and whether there wasn't a violation. However, I'm now wondering, since let me just make it more generic. Does a donation to the GoFundMe to start it, does that count as an expenditure? If it does, then this is definitely, it fits the definition of direct campaign expenditure. That is not something that I have expertise in answering, and I don't know if anybody on the commission has that expertise. And I'm being very, very picky about this and being very precise. We're talking about direct campaign expenditure, and the definition reads, direct campaign expenditure means an expenditure, which is spending of funds. It doesn't say whether you put it in after or whether you had to buy something to start that campaign, right? GoFundMe is free to start up, but Mr. Swingler just mentioned that he believes that he had to, I guess, prime the pump, I guess, in a way, right? Start that campaign off with an amount, and he did donate to that. So that is expending funds. It is for electioneering communication or for express advocacy. So that is a very important definition that I need to understand to make a determination on this complaint.
I would just ask you to. I just verified with GoFundMe. You could Google this, but there's no requirement whatsoever for the organizer of the GoFundMe to donate to it. So my donation was just that, a donation along with anyone else's. So my initial donation was not like required by GoFundMe, if that makes sense.
Yes, so thank you for clarifying that. It does clarify half of the question for me. The other half is, does your donation count as an expenditure, since you were the person who started the GoFundMe campaign, correct? It was under your name or tied to you as. Is that correct?
Yeah, the GoFundMe was created by me. Definitely a cause that I would be supportive of and donate to as well. Yeah.
Sure.
So, Mr. Chairman, I'd like to make a point of order that the question as to the legal definition of a direct campaign expenditure is not an appropriate question for the respondent. It may be for his attorney.
Yeah, that's why I was about to go forward, and you saw I can't share anymore. I believe sharing has been disabled, but I do have it up on my screen. If you want to see the section, so the entire board or commission can see the particular section where the definition is. There we go. A direct expenditure means an expenditure for an electioneering communication or for express advocacy. And any donations that he made to himself because those funds came directly back to his bank account, regardless of whether he knew that or not, was not for any express advocacy, and it was not for an electioneering communication. The GoFundMe page was free of charge. There was no charge. There is no charge to people who post those campaigns, and he never expended a dime for electioneering communications or express advocacy for any issue. Just because he donated to a GoFundMe page that he owned, which is his own money anyway, or he donated to Save Austin Now and as an individual, does not make that express a donation for election communication or for express advocacy. That's our understanding.
No, I appreciate that. And actually, I have another related question, which is, in either counsel for the respondent or the respondent can answer, but do you have in your possession a copy of, because I think the complainant had represented that the GoFundMe is no longer available, the page isn't available, you can't read what the GoFundMe landing page said. Do you have a copy of, I guess, the description and kind of the call to action that was in the GoFundMe website that was telling presumably prospective donors what this was about, why it's important to donate, things like that? Do you have a copy of that?
I think Joe may. I deleted it shortly after I donated the money to Save Austin Now because didn't want to raise additional funds. But I think Joe might have. I think there's a screenshot he has.
Yeah, I'll pitch it to the complainant. Complainant, do you have a copy of this that I missed somewhere?
No, Mr. Chair. I regrettably did not take a screenshot of the landing page when it was open, but I do have a screenshot of it saying the fundraiser was deactivated, that it had raised its $30,000 goal. Now it's a 404, but even if you still Google Mr. Swingler's name with the information, it'll still pull up and say, like in the description line, that, quote, over $10,000 of my own money has been donated. I don't know if Mr. Swingler wrote that. Again, it's a 404, but that still appears to this day on Google.
Okay, and so, but I want to just make sure that I'm understanding. Just a kind of quick yes or no from complainant or counsel and quick yes or no from respondent. Do either of you have in your possession a copy of what a prospective donor would have seen had they visited the GoFundMe page? Yes or no?
No, sir.
No. Respond.
Counsel does not, and I believe Mr. Swingler does not, because he had.
No, we don't have it. We deleted it back in March.
Okay. That's fine. All right. Commissioner Greenberg, I see your hand. Go ahead.
Mr. Swingler, would you say that the people who donated to the GoFundMe were expecting that money to be spent on billboards?
Yes, that was the intention of the fundraiser. Yes, ma'am.
And would you consider that to be, in their eyes, a direct expenditure when the billboards were put up?
I think it was a support of my effort to raise awareness for property.
Like, do you think they would have understood that they were giving money that would become your own personal property?
I'm not sure exactly what you mean by that question. I think
well, your lawyer said that the the proceeds from a GoFundMe campaign become the personal property of the person running the campaign. Do you think that was the expectation of the donors?
Yeah, I mean, if you donate to a GoFundMe, of which I've done multiple times, like the money goes to whoever's raising it. So, I mean, it was deposited directly into my, checking account from GoFundMe.
But they had the expectation that that money was going to be used for billboards, for Prop B.
Yes, absolutely.
Thank you.
So I want to, if I can answer for the expectation of the donors, it discloses that on the GoFundMe website specifically for anyone to be able to see that it can
discloses
be
what?
That it becomes the personal property of the fundraiser, and it can be used for any purpose or no purpose that was disclosed at all. And so they warn donors that you're not necessarily going to have those funds used for whatever purpose that they were disclosed. And he intended to put billboards up, but he figured out that he couldn't legally do that. And
I understand. But the money was used for the purpose that the donors intended.
Actually, no. The purpose was for me to put the billboards up and to have, me contract with the billboard companies. We were told that I'm not allowed to do that because I'm not a PAC. So I gave all the money to Save Austin Now PAC, and then, they did their own billboards.
And once you gave that money to Save Austin Now PAC, they could make billboards or they could choose to do something else to promote that cause. They were under no obligation under state law or even the Austin City Code to take any specific action with regard to their contributions.
Thank you.
Chair Soberon?
I believe he's gone. I don't see.
Oh, okay.
Hang on just a second. Chair Soberon is having some connection difficulties, so let's just hold on a sec.
How about a 5-minute break?
Do you want me to just go ahead and call on folks?
He texted me, and I'm about to. He should have the call-in number, but I'm about to text it to him as well.
For the sake of time, do you mind if we continue this discussion?
No, we need to wait.
Good time for a humanitarian break.
Secretary Lerner, if you want to call a recess because you're next in line as presiding officer, you can call a 5-minute recess. That's fine.
I would like to give everybody a 5-minute recess. So it is now 9:18, so we will resume precisely at 9:23. So I believe, Lynn, are we good? If Luis is audio connected, should we continue?
I'm good as long as we have confirmed that everyone is back.
When are you there, Ms. Stanton? Commissioner Stanton? Okay, great. Okay. Donna Beth, okay.
Everybody's back and Deborah's still moving.
Deborah's still moving. Hit the treadmill desk like me, Deborah. You'll be so much happier. Okay. Who was next in line for questioning? Oh, Commissioner Tenayuka?
I have a question for Mr. Swingler. I understand that the GoFundMe page platform is free to use, but they do charge a 1.9% and a 30-cent per donation fee. Who paid that fee?
Say that again.
So the GoFundMe page is typically free to use. The platform is free to use, but there is a fee for using it at 1.9%, I believe, and 30 cents per user per donation.
Okay.
How was that paid for?
The donors. That's deducted from the donations. It's disclosed to the donors as a credit card processing fee.
So 100% of the donors paid for that. There was nobody that just said, no, I only want to make this donation and not contribute to the fee. Has that been verified?
Yeah, I think the way that it works is like you get charged like a fee when you do your donation, or it's like a shipping and handling fee almost.
It's optional. So I'm just curious, has it been verified that everybody took the option that they wanted to pay to cover that fee, or is that known for sure that somebody didn't opt out? Because they do have the option to say, no, I don't want to pay the fee. I just want to make the donation of X amount of dollars.
I guess the question, Mr. Swingler, is did you pay GoFundMe at any point for fees?
No. Yeah, I never paid GoFundMe throughout the process. I just was the recipient of funds that that GoFundMe page received, took those funds, donated to Save
Okay.
Us Now.
So let's just say you were the number, whatever the final, do you know what the final number was that was donated? The exact amount?
Exactly $30,000.
So exactly $30,000 is donated, and you received exactly $30,000. Nothing more.
Correct, and donated that money to Save Us Now.
Okay, and I'm sorry if I missed this, and I know this question was asked, but you did make a donation, but I don't believe I heard how much you made yet. Or is that kind of, it's on the spreadsheet that maybe you guys are going to share in this call?
I think I'm still confused. We're happy to, it's all public info. It's been sent to Save Us Now. We're happy to just pull that up, but I'm so confused as to why my contribution amount matters.
Well, but I'm happy to. I agree with Mr. Swingler. I don't really understand the relevance of it, but he doesn't have the spreadsheet in front of him, but I do. I only see $1,000 that was in there from an Otto Swingler.
No, that's him.
It's public information.
Yeah, and that's all been given to Save Us Now. I mean, I've donated multiple thousands of dollars to Save Us Now, so I couldn't really quite remember, how much I gave to my own GoFundMe, but it's all in the spreadsheet. It was sent to Save Us Now.
Sure.
Okay.
Commissioner Levins and then Commissioner Stanton.
A couple questions for Mr. Cascino. And I'll ask everyone to forgive me if these are rookie questions, because I am admittedly a rookie. But if I understand right, your complaint is supposed to give us a description of the evidence you intend to produce to prove your allegation. For your second and third complaints, they both relate to direct campaign expenditures. Is there any evidence that you have not noted in your complaint of any direct campaign expenditures made by Mr. Swingler or anyone else related to this complaint?
No, sir.
Okay. And the first part of your first of your three complaints is related to political advertising, electioneering communications, and express advocacy. Is there any evidence that you intend to offer to this committee if we have a final hearing of political advertising, electioneering communications, or express advocacy by Mr. Swingler?
Yes, sir. I have a screenshot which details that he's the organizer of it, as well as that the $30,000 had been raised. And I also have a screenshot then that was post, not the landing page as we talked about earlier. I also have a screenshot related to what it looks like now, which is a 404, but there's still just in the description a mention of somebody spending $10,000 of their own money and printing vinyl for blank. And I will present both of those screenshots as well.
Okay, but just to be clear, they're evidence of statements about a future intent, but they're not evidence about any actual payments for political advertising, electioneering communications, or express advocacy.
Well, the word spent is in the past tense, and so I think that would show a past expenditure.
Of what?
Well, it says, the description that still is there, if you Google it, says that I have spent $10,000 of my own money creating artwork and printing vinyl. So, and it's related to, this fundraiser. That's still there because of whatever Google error. And I will present that as well.
Okay, so an expenditure of, and I everybody else is louder than you. So I'm struggling. Something about printing vinyl?
Yes, sir. There's, the quote that is still there that you can see because of Google didn't completely erase it. And sorry, my laptop's kind of low on the computer. If you can't hear, my microphone might have been covered a little. But it says that I have spent $10,000 of my own money creating artwork and printing vinyl for, then it cuts out. But somebody spent $10,000 on something. And I don't know if it was Mr. Swingler in particular, but since he was the organizer of the fundraiser, and since, the description had been presumably written by him as he organized the fundraiser, that was in there somewhere. So I would assume it's him.
That's just the description of the GoFundMe, just to be clear. And I'll just verify what I've already verified numerous times throughout this call. No money was spent by me. All the money, in order to follow the PAC rules, was given to or donated to Save Austin Now. You can verify that with Save Austin Now if you want to. They were the only ones who spent any money, just to be clear.
All right. May
I be recognized, please?
What was that?
Deborah?
I saw Commissioner Stanton's hand, but okay. Yeah, go ahead, Commissioner Stanton, and then Danberg.
All right. Thank you. It's a fair question, Mr. Opiella and Mr. Swingler, to ask why I keep asking, and perhaps some other commissioners keep asking, if Mr. Swingler contributed any money to the GoFundMe. For me, I'll speak for myself. For me, I still am not clear. I'm trying to determine the definition of expenditure. And so for me, if my logic thinking here is if Mr. Swingler had contributed to the GoFundMe, that is money that he had spent, right? Money from him to this. So that's why I keep asking that question. And what was the goal, Mr. Swingler, of the GoFundMe? I think I've heard it alleged by Mr. Cascino, but I'm not sure that I've actually heard it from you. What was the goal of that GoFundMe?
The goal of the GoFundMe was to do two things. One, raise awareness that we had an upcoming election, via like, hey, look, this is a good reason to talk about this. I'll send this GoFundMe link to, friends and family and whoever. And then two, to raise money to create, advertising via, whether it's going to be wild poster campaign or billboards or whatever it was. So throughout the process of raising that money, I was told, hey, you probably shouldn't just go buy these billboards because this is a vote for Prop B. You should make sure you follow the rules with a political action committee. I thought I went to great lengths to do that, coordinated everything with Save Austin Now, donated all the money to Save Austin Now, had them, take it from there. So I'm just, I guess I'm still a little bit confused. I guess I'm a little confused as to the relationship of Save Austin Now buying billboards, with the money I donated to them, like I clearly didn't contract for any billboards. I just want to make sure that's clear. Like I didn't buy any billboards.
Yes, and I want to clarify. I'm not interested just because of the complaint. I'm trying to keep it focused on the complaint, and the complaint isn't what you did with the money afterwards when you found out, right? What you donated the $30,000 to Save Austin Now. I believe the complaint is against the GoFundMe and the process in which that was that it violated direct campaign expenditure code, and so and it comes back to the other definition that I'm trying to reconcile for myself, and that is the definition of express advocacy, because from what I understand, the GoFundMe page is exactly that. It was for express advocacy, but I wanted to hear from you what the intention or the goal of that GoFundMe was. And thank you for clarifying that the two goals. You said raise money to create advertising. Was this advertising in support of raising awareness about an election? Hey, there's an election coming up. Know the issues that are at play, or was it targeted for a specific motive, as in to say vote against or for a particular ballot measure? Does my question make sense? I'm sorry, I was a bit long-winded, Mr. Swingler. Your second goal was to raise money to create advertising. What was the message of that advertising? Was it just general, hey, an election's coming up?
No. That was the whole reason we donated the money to Save Austin Now PAC, was because it was political advertising. It was specifically for voting a specific way in a specific election. That reason, we donated all the money to Save Austin Now PAC.
Gotcha. Thank you. Okay, that's what I thought. Okay, thank you.
To specifically answer your first question, Commissioner Stanton, I want to be very clear here that there were no funds expended by Mr. Swingler in express advocacy. There were no funds that were expended by Mr. Swingler to make a direct expenditure, even though he had planned to do so, because he realized that he couldn't do so without creating a PAC. Okay, and so that's why he chose to then donate those funds, including funds that he donated to himself, not knowing how that worked. And at no point did he cross that $500 threshold in an expenditure for express advocacy or an electioneering communication.
I guess. Oh, go ahead, Commissioner Stanton, if you had a follow-up.
Yes, I guess that's where I'm not clear, Mr. Opiella, is we go back to the definition of expenditure. And, there is no guidance. I guess, some code kind of assumes a common definition of expenditure, right? There's definition of direct campaign expenditure, right? And in the definition, it says expenditure without explicitly defining what do we mean by expenditure, right? And what I'm trying to figure out is donating to a GoFundMe campaign that is free of charge to start up, right? That I'm not arguing. Is donating to that GoFundMe page, even though you started it, with the goal of express advocacy, does that count? Does that donation count or contribution count as an expenditure on your part? You're the person who makes that contribution.
So the definition of expenditure is in your city code, and I will share that with you right now. Give me one moment. So under 2-2-2, under definitions, it states expenditure means a payment of money or other thing of value, including an agreement made or other obligation incurred, whether legally enforced or not, to make a payment. He never made a payment to GoFundMe, to advertise, to have express advocacy, to do whatever. he never made a payment of money or other thing of value to anyone other than Save Austin Now PAC, which is what he made the expenditure to, and Save Austin Now PAC then reported that on their campaign finance report. Your Austin City Code doesn't incur an obligation on the donor to make a disclosure, to file their own report. It makes that obligation on the recipient.
Thank you for that. That's very helpful. I appreciate that help. And I just have one more question, Chair, if I may continue. With respect to the, I understand that neither party has a screenshot or evidence showing the GoFundMe page as it existed at one time. One thing I do see in the complaint is the GoFundMe link, and in the name of the link, it's HTTPS blah 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 GoFundMe / after that is reinstate Austin camping ban, save our city lists. Mr. Swingler, would you agree that a reasonable person would expect that to mean that is definitely advocating, that is express advocacy, advocating for a particular stance? And I think you have already clarified that before, that yes, you were intending to raise funds to create advertising for a particular direction.
Oh yeah, without a doubt. I if I didn't make that clear at the beginning of the call, I apologize. But yeah, crystal clear. Okay. Direct vote. Vote yes on Prop E was very directly the message, and very directly the message everyone who donated to the GoFundMe was supportive of. For that reason, just to make sure I'm clear, for the reason that it was political messaging, we donated all the money to Save Austin Now to make sure that we followed the rules. I guess I'm unclear. I think we're all on the same page. It was for Prop B,
okay.
Billboards.
Thank you.
Okay.
That's it.
Thank you. Commissioner Kale and then Commissioner Danberg.
Okay, I'll be fast. What I see is that Mr. Swingler got enthusiastic about something going on in our city and wanted to participate in that. And when he learned what the political rules around that were, as he was raising money, he wisely, in my opinion, decided to follow those rules and just donated it to Save Austin Now. In my experience, I have an MBA. I don't see any expenditure having taken place from the GoFundMe toward any goods or services. And so my only concern is, maybe on Save Austin Now's, and they could have reported some of these donors faster or that kind of thing. But I don't see anything really nefarious going on Mr. Swingler's part. The other thing, of concern, obviously, is that people will learn, politicos will learn, hey, I don't want them to see this as a way to raise funds sort of in parallel with a political action committee. But that said, I still don't see anything really, like I said, nefarious going on with what Mr. Swingler did. He got excited. He wanted to raise money through GoFundMe. He learned the rules and he switched direction. That's my take on this.
Mm-hmm. Thank you. Commissioner Danberg, go ahead.
I'd like to circle back to what Mr. Cascino said the last time he spoke, just for some clarification. It sounded to me like what he was saying is that someone, apparently Mr. Swingler, or the GoFundMe page or whatever, somebody said that they spent $10,000 for artistic design, I guess for billboards, and for vinyl, I guess, for billboards. And so who made that $10,000 expenditure? And was the claim I made the expenditure not really what happened?
Yeah, Deborah, I think I can clear that one up pretty easily. I just worded my GoFundMe that way in order to kind of like create hype or momentum, so to speak. Just to be crystal clear, I didn't actually spend $10,000, not spend any money directly for billboards, period. Donated all the money to Save Austin Now PAC. I assumed that I would have, based upon other people in the community that also, work and live downtown and have been, very passionate in this subject as well. I assumed that I would have very, immediate support of this, and I did get that, but I didn't. When I wrote in the GoFundMe, hey, I spent $10,000. That was more so just to say, hey, like it'll be easier to raise 15 or 20 if people think we're halfway there, and it was just more of a marketing sentence. But just to be clear, I didn't actually spend that money.
Commissioner Levins, I saw your hand, so go ahead.
Yeah, I for one, we're getting close to our 10 o'clock. I'm going to make a motion to dismiss the complaint in its entirety because it does not give us reasonable grounds to believe a violation occurred. And I'm happy to explain my reasons for that if we want to deliberate that before we vote.
There is a motion on the floor. Is there a second?
Chair.
If this is a procedural question, then I'm happy to take it. Go ahead.
Yes, sir. I'm asking that motion be restated because I can't vote on it the way it's worded. Because I think, Commissioner Levins, you added your rationale for it as well, and I want to vote on the motion without rationale. Does that make sense?
Sure. Go ahead.
I was only stating the rationale of that. I don't believe there's reasonable grounds to believe a violation occurred because it's my understanding that's what we're supposed to do. But I'm happy to amend the motion to say I move to dismiss the complaint.
Well, I think that was actually a perfectly appropriate way to frame that motion. And that's kind of tracks very closely to the language we use in motions like this. We say, because that's what the city code says, is that you can dismiss it if there are not reasonable grounds to believe that a violation occurred. So that was an appropriately phrased motion. And I'm still waiting on a second if there is a second.
I will second that.
Okay. A second by Commissioner Stanton. So discussion on the motion. If Commissioner Greenberg, go ahead. Make sure to unmute yourself.
Just blab, 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 like Charlie Brown's teacher. I think this is simply a way to circumvent the intended rules to disclose donors for campaign. This is a donation for campaign expenditures. They donated the money. It went to Save Austin Now. Save Austin Now put up billboards. And in the meantime, I think May 24th, they disclosed the GoFundMe donors, which was well after the election. So those that donated were not disclosed to the public. We have these campaign finance rules so that the donors are disclosed to the public in a timely manner. And this was a way by having a GoFundMe campaign and then later just saying that. I just don't buy that no, there are reasonable grounds to believe a violation occurred. So I'm going to vote against the motion.
Okay. Commissioner Levins, I saw your hand, and then Commissioner Stanton.
So I have a couple of things up. Obviously, I'm speaking in support of my own motion. That would be weird if I did otherwise. And Commissioner Greenberg, I respectfully disagree. And the main reason I do is that what Mr. Swingler did is precisely what we would expect someone to do. I agree with Commissioner Kale, I believe, who said he got excited about an issue in our city. We want people to do that. He started to take action to speak. We want people to do that. When he realized that there were rules against doing it in the way that he wanted to do it, he changed his course and corrected that. That's what we want people to do. We have a fairly Byzantine campaign finance code. I'm not sure that that's avoidable. But he did exactly what we want to do, and to haul him before this board has a great chilling effect on people engaging in political speech. We want more engagement and not less. And aside from all of that, the reality is there were not direct campaign expenditures. That there's no evidence that there were direct campaign expenditures made. That definition is a very important one, and a donation to GoFundMe does not meet that definition. And there's no evidence of of actual political advertising being done by Mr. Swingler. He took the money and gave it to Save Austin Now. So even if we think that Mr. Swingler had a nefarious purpose, which intent is not an element of a violation of these statutes. But even if we think he had a nefarious purpose, if no direct campaign expenditures were made, then no violation occurred. And if the council or legislature or someone wants to amend the code to change that, well, that's an issue for a different day. But I think this has a great chilling effect on people like Mr. Swingler who are not political professionals, who say, I want to get involved and I want to make a difference in my city. And this is something that will boomerang to both sides of issues like this if we countenance this sort of a complaint. And that's all I have. I will be voting for the motion.
Thank you, Commissioner Levins. I really appreciate it. I am going to very briefly move. So in the interest of our 10 o'clock deadline and the fact that we have to affirmatively move to go past 10 o'clock, just in the interest of making sure that we don't accidentally run afoul of our own rules and abruptly adjourn at 10 o'clock, I'm going to very respectfully move to table the motion temporarily, just so that we can take care of that and then come back to the motion, if that's okay.
I don't oppose that tabling, Mr. Chairman.
What was that?
I do not oppose tabling for purposes of that vote.
Okay, then I will move to temporarily table the motion. I'd appreciate a second. Quickly. Thank you so much, Commissioner Levins. Then it is tabled. Then I don't know if a second.
We have to vote.
Sure. Let's have a quick roll call. I'm not sure. My Robert's rules is somewhere else in this house, but we'll do a quick roll call vote. So I will call your names as they appear on the agenda. If I can pull up my copy of the agenda, here it is. So please unmute yourself. I will say your name, vote aye, vote nay, vote abstain, and then I will repeat your vote back to you to confirm it. So Chair Sobran votes aye. Vice Chair O'Hurry is absent. Secretary Lerner? Could you say that one more time? I don't know if you caught it.
Aye.
Thank you. Secretary Lerner votes aye. Commissioner Danberg?
Aye.
Commissioner Danberg votes aye. Commissioner Greenberg?
Aye.
Commissioner Greenberg votes aye. Commissioner Kale?
Aye.
Commissioner Kale votes aye. Commissioner Laurie is absent. Commissioner Levins?
Aye.
Commissioner Levins votes aye. Commissioner McCormick?
Aye.
Commissioner McCormick votes aye. Commissioner Stanton?
Yes or aye.
Commissioner Stanton votes yes and aye. And Commissioner Tenayuka?
Aye.
Commissioner Tenayuka votes aye. That carries unanimously with 2 commissioners absent. So that motion is temporarily tabled. I'm going to make a privileged motion that we go past 10 o'clock. Is there a second?
I second.
That was a race, and I think Commissioner Kale won. So that's seconded.
Boom.
Assuming there's no discussion, I'm going to run through the roll call. Any discussion? Okay.
We voted. Let's go.
Let's go. So Chair Sobran, I vote aye. Vice Chair O'Hurry is absent. Secretary Lerner.
We voted aye, yeah. Let's go.
Aye. Well, we're voting on a new motion. So Roberts would roll in his grave if we didn't do this right. So that was an aye from Secretary Lerner. Commissioner Danberg.
No.
No. Going past the clock from Commissioner Danberg. Commissioner Greenberg.
Yes.
Commissioner Greenberg votes aye. Commissioner Kale.
Aye.
Commissioner Kale votes aye. Commissioner Laurie is absent. Commissioner Levins.
Aye.
Commissioner Levins votes aye. Commissioner McCormick
Yes, aye.
votes aye or yes. Commissioner Stanton.
Yes or aye?
Commissioner Stanton votes yes or aye. And Commissioner Tenayuka.
Yes.
Commissioner Tenayuka votes yes. So that was 1, 2, 3, 4, 5, 6, 7, 8 ayes, 1 nay, and 2 absent. That motion prevails. Okay, then I'm going to recognize Commissioner Levins to reintroduce his motion.
So I reintroduce my motion that had been tabled to dismiss the complaint in its entirety because there are not reasonable grounds to believe that a violation occurred.
Okay.
I second.
Commissioner Stanton seconds again. Back on the motion. Thank you for bearing with me and for bearing with Mr. Roberts. Okay. Any other discussion on this motion, Commissioner Stanton?
Yes, I want to support Commissioner Levin's stance of the motion, and I want to support and also support both parties in this complaint here. Mr. Cascino for also his passion in bringing forth when he feels that there has been a violation. So, Mr. Cascino, I hope that you are not discouraged by doing what you believe is right. And I also believe that Mr. Swingler, I applaud you for your motivation and your passion in getting involved as well. I would like to kind of, I guess, remind our commission, and let me take a step back. My perspective is my charge as a commissioner on this commission is not to pass judgment or make judgment as to an individual's intent when they make a complaint or when they are responding, whether they have nefarious intent or not. My charge, as I understand it, is to decide a complaint factually based on, one, if it falls, since it falls within our jurisdiction, here are the rules, and does it meet the definition of the charge that's alleged here? And so, like Commissioner Levins, my vote, whereas I saw the passion and I'm not here to doubt really people. I think I also agree. I forget which commissioner who said, I think it was Greenberg, who said that she believes that this is just a kind of a way to circumvent it. I also agree with Commissioner Greenberg that definitely could be a consequence. It's a reasonable consequence. And I share your concerns with that. But I am taking my charge as commissioner on this commission very literally as here is the alleged violation. Here's the code. We got to the definition of the code. Is there, and for me, once I got clarity on the definition of expenditure, so I thank you, Mr. Opiele, for that, then it became clear to me from my perspective that it does not meet the definition of direct campaign expenditure. And on those grounds, I will be voting to dismiss this complaint. But again, I want to express my gratitude for both parties in this and sticking it through and doing what you believe is the right thing, regardless of which side you fall on.
Thank you, Commissioner Stanton. And I'll briefly offer a comment that on the question of intention, that's something we usually, if we find that there is a violation, when we get to the sanctions, like what the consequence is, that's when we usually do intention questions, unless the code specifically says that a violation has to occur with a specific kind of intention. they had to have done it knowingly or intentionally or something like that. But it's an astute observation, and one that I appreciate about what we're doing at this stage. Commissioners, any other discussion on the motion? I have some thoughts I want to share, but I want to give deference to my fellow commissioners first. Okay, Commissioner McCormick and then Secretary Lerner.
No, let's go ahead and vote.
Secretary Lerner, do you have something you'd like to say before we comment, before I give some thoughts of my own and then maybe proceed to a vote?
Well, I would like to hear your thoughts. I mean, one of the things that I wonder is that I think the question, there are lots of kinds of expenditures that need to be reported in campaign finance. But one of the things I do wonder is, we haven't seen the Save Austin Now, the financial disclosure. And I guess I'm a little confused as to, what we're looking at Mr. Swingler for if he made a donation to Save Austin Now and that was disclosed. And then Save Austin Now made the expenditure for the billboard. I'm a little concerned. I don't want to set a precedent that this is a way for people to raise money and then give it over and then hide. And I'm not saying this is you, Mr. Swingler. I'm just saying we do have to worry about kind of precedent that it becomes an avenue of okay, now we can get kind of around disclosure rules. At the same time, I mean, the entity that paid for the billboard ultimately was Save Austin Now. And they need to disclose their donors. So I'm a little confused as to exactly what I'm looking at Mr. Swingler for. I will admit to that. So I don't know if that means that we need to go to a hearing so I can understand that better, or if it means it's dismissible. So just to say, I look forward to hearing your comments, Luis.
Sure. So I am struggling. I will be completely honest and transparent, because on the one hand, we try our best, and we struggled with this in other complaints in the past, our very recent past, commissioners. We try to give deference to the non-professional complainant, right? The complainant that says they see something wrong and they try to back it up, right? And where I struggle is that, the complainant has represented things that could amount to violations of code, and I think reasonably could be violations of code, which sort of is our task right now, whether or not there are reasonable grounds to believe that a violation has occurred. I think what is implied in that, though, is that the respondent committed those violations. I don't know if there's quite enough to go on. It is a genuine struggle, because I do think that there are consequences to this kind of decision that go in both directions. On the one hand, a chilling effect for people who are just getting enthusiastically involved in politics, something that I wish more people would do. And then on the other hand, you do have the precedent that is set, well, if I just bundle my campaign contributions in a GoFundMe and say, oops, sorry, and then send it to a PAC, then it's okay. Again, not saying that this is what happened in this case, but more sophisticated participants in our political process can take a cue from what we do right now. So I do think that I will likely be voting for the motion, and I just want it kind of clear and on the record that something that the complainant said in the course of the Q&A and in the course of his presentation, that there was something that specifically the Google result that shows up and says, I personally spent this much money on artwork and vinyls. I don't know who the first person I is in that statement. That was never really 100% clear because we don't have the full copy of that statement. But it seems to me that unless the artwork and vinyls presume, and I'm reading too much into this, which is why I have to support this motion. But if it's the case that someone was producing artwork and vinyls in support of Proposition B, that kind of stuff amounts to an in-kind, what we call direct campaign expenditures in our city code, but an in-kind contribution to the Prop B effort. But whether or not that means that the respondent, whether or not that means there are reasonable grounds to believe that the respondent sitting before us right now committed violations, I don't know if it quite meets that admittedly low threshold. So I'm inclined to support the motion as well. But Commissioner McCormick, go ahead.
Since I've been doing this more years than any of y'all are old, 12 here is my 2 cents. He collected the money from GoFundMe by the rules. He gave the money to Save Austin Now in good faith. How Save Austin Now reports it, and etc. We've got them coming up. We'll find out later. We can also tap into them because they received the money. So I'm voting for the motion. I've been down this road a few times.
Appreciate that, Commissioner McCormick. Commissioner or Secretary Lerner? Nope. Okay. All right. Secretary Lerner.
Yeah. Okay. So the question is, so to complainant, whether he would then monitor the disclosures of a Save Austin Now.
So now's not an appropriate time to ask the parties direct questions. I think we can make suggestions to parties moving forward. So, for example,
neither here nor there. Honestly, it's neither
sure.
here nor there.
Sure. In the interest of time, since we are at 10 o'clock and we do have other things to take care of tonight, are there any other questions or comments or discussion on this motion specifically from the commissioners? Commissioner Stanton.
Yes, thank you, Chair. I also want to echo your struggle and thank you for sharing that and being vulnerable. It was a struggle for me too, and one of the things that stood out for me was that Google quote as well. And Mr. Swingler did admit that he wrote that, so that was no longer a question. But he did provide a response now, and it is a reasonable, whether I believe it or not is not the question. For me, it was more he provided a reasonable response. I can understand the logic in priming the pump and starting that by saying something like that, right? So it's been a hard one, but I go back again to what is the question that I am being asked here in determining this complaint. I guess I just wanted to echo your struggle and the difficulty in this complaint.
Well, I appreciate that, Commissioner Stanton. Just really quick, just a question to my fellow commissioners, because I think I might have missed this and it might be important to me. So the respondent confirmed that he was the author of the Google statement, that was part of the description that he had written as part of the GoFundMe.
That is my recollection. He said that yes. He did, but he didn't. But it wasn't truthful. He was doing it as a marketing ploy, correct, to garner support for for
Well, now
that's my recollection.
I know.
Sure. No. Here's why I ask that and why I think it's important. Because if that's the case, then we.
Makes it tougher.
We're getting
It makes it tougher for me, but I think in the interest of time, in the interest of expediency, I'll do the following before we jump into the or no, actually, let's do the vote, and then I'll have some comments after the vote, so parties stick around. Secretary Lerner, go ahead.
Okay, if there's this much question, it's not a problem to take it to a final hearing where we can have more time to look at the evidence.
Right.
I agree.
Right. That's the struggle for me too, because it is a low threshold. It really is. Reasonable grounds to believe that a violation occurred. It's not like we don't need like rock solid proof at this stage. And parties and complainants file complaints precisely because they think that something wrong happened. And the final hearing process is supposed to be kind of an opportunity for discovery. I apologize that if I seem like I'm waffling. It is an incredibly close call for me. I think I've made up my mind that I personally will vote against the motion, but I respect everyone's vote and opinion and participation, and take no umbrage against anyone who doesn't vote like I do. So if there's any other discussion, I'm happy to hear a final word. Other than that, we'll go to a vote.
Let's vote.
Okay. Thank you for that, Commissioner McCormick. Okay, I'll call names as they appear on the agenda. And please unmute yourself, clearly state your vote. I'll repeat your vote back to you to confirm. Chair Sobran votes no. Vice Chair O'Hurdy is absent. Secretary Lerner.
We can't hear you.
I think I'm not giving it a chance to actually know.
Secretary Lerner votes no. Commissioner Danberg.
Aye.
Commissioner Danberg votes aye. Commissioner Greenberg.
No.
Commissioner Greenberg votes no. Commissioner Kale.
Aye.
Commissioner Kale votes aye. Commissioner Laurie is absent. Commissioner Levins.
Aye.
Commissioner Levins votes aye. Commissioner McCormick.
Aye.
Commissioner McCormick votes aye. Commissioner Stanton.
I am actually changing my vote to a no.
Commissioner Stanton votes no. Commissioner Tenayuka, sorry.
We can't hear you. You're muted.
Try one more time.
No.
No. Commissioner Tenayuka votes no. There being 4 ayes, 5 nays, 2 absent. The motion fails. So with that, we are able to entertain another motion, commissioners. And I'm happy to take it from whoever is the Secretary, Commissioner Greenberg.
I move that we go to a final hearing. I believe there's reasonable grounds to believe that a violation may have occurred. That's our standard.
Okay. That is the motion. Is there a second? Is that Tenayuka?
I'll second that.
Okay. Motion by Commissioner Greenberg, seconded by Tenayuka. Discussion on the motion.
I want to see evidence. Can we talk about that, or?
That's next.
Yeah, we'll talk about that next if there's specific evidence that we want to request as a commission.
Okay.
Okay.
All I would say is this is just the inverse of my motion. So all of the comments made either in support of or in opposition to my motion just apply the opposite here. In the interest of time, I would suggest that we move to a vote on this motion.
Okay. Well taken. Thank you for that. Okay, then I'm going to do the same thing that I just did. Unmute yourself. Please give it time to register that it's unmuted and clearly say your vote. So I'll go in the order that it appears on the agenda. Chair Sobran votes aye. Vice Chair O'Hurdy is absent. Secretary Lerner?
Aye.
Secretary Lerner votes aye. Commissioner Danberg?
Aye.
Commissioner Danberg votes aye. Commissioner Greenberg?
Aye.
Commissioner Greenberg votes aye. Commissioner Kale?
No.
Commissioner Kale votes no. Commissioner Laurie is absent. Commissioner Levins?
No.
Commissioner Levins votes no. Commissioner McCormick?
No.
Commissioner McCormick votes no. Commissioner Stanton?
Yes, or aye.
Commissioner Stanton votes yes or aye. And Commissioner Tenayuka?
Yes.
Commissioner Tenayuka votes yes. That is, 1, 2, 3, 4, 5, 6. Okay, 6 ayes, 3 nays. It has a majority of the commission and is passed. So with that, we now can discuss specific evidence that we, the commission, would like to see. And I think what we've traditionally done at this stage is solicit input from the parties. What we might do, though, because it is so late, is have a brief discussion, commissioners. If there is evidence that you know right now that you want to see in a final hearing, we can discuss it and have a separate motion that this is evidence we definitely want to see, but then otherwise we can admonish the parties that they work with our counsel, Lynn Carter, who's representing the commission on this, to discuss what evidence is agreeable between the parties. And if there's significant disagreement, we can take that up at a further meeting. But see Commissioner Danberg.
I would like to ask Mr. Cascino to bring us that Google page and any screenshots that he has. And I would like to see the Save Austin Now reports that report the individuals who contributed to the GoFundMe page. So I guess that's from Mr. Swingler and his attorney. Those are the main things I'd like to see, please.
Yeah. Commissioner Greenberg?
I'd also like to see the information that was provided to Save Austin Now on the individual donors, including whatever was provided that was not sufficient, and then later what was sufficient, along with the dates that that information was provided. I'd also like to see a GoFundMe webpage. I believe Mr. Swingler has one up now. The entirety of what's on the page, including where it says the money goes.
So I think to that end, what I was actually going to suggest is if it is possible I think more information about GoFundMe generally would be useful. How the fees are collected and how the fees are paid to GoFundMe is one question that's worth exploring. But I think what I was actually going to ask Respondent and Respondent's Counsel to try to do is to find a cached version, or sort of like because nothing on the internet is never and things last forever. And clearly there is some version of that GoFundMe page with the full description that exists. Otherwise, Google wouldn't have a kind of preview of a link that no longer goes anywhere. So if at all possible, to retrieve the kind of full GoFundMe page. And if it's not possible, it's not possible. And I don't want to ask you to do something that is physically impossible to do. But to retrieve a copy of the GoFundMe page as it existed at the time of the alleged violation, or at the time when it was live and accepting donations. So, and I think that would kind of help with what you were asking for, Commissioner Greenberg.
Yeah, I just think it might not be possible to get that one, but you're probably right. They say you put it on the internet, it's there forever. But there is another GoFundMe page that's active.
Sure. I think,
Commissioner Greenberg, are you talking about my GoFundMe that was to go towards Community First Village?
Yes, I don't see anywhere on it where it says that the money goes to your personal property.
That is a GoFundMe that is deposited directly with Mobile Loaves and Fishes. You can select nonprofits. So after Prop B passed, I set up a Help the Homeless Get Housing GoFundMe, and we've raised, I think, about $11,000. But you could contact Mobile Loaves and Fishes to verify that if you want. I have no access to those funds. I simply was the creator of the GoFundMe.
Okay. Thank you for clarifying that.
Sure.
Commissioners, are there any other things that you would like to see as evidence in a final hearing? And then I think we can, I'll ask Glenn about the appropriate procedure, but I want to leave the floor open for commissioners if you have another item. Secretary Lerner?
Did we already talk? I mean, obviously the spreadsheet. I'm sorry I missed that, but also the Save Austin Now's financial disclosure.
Yeah, I think that was one of the first things that was requested is the list of donors as it was sent to Save Austin Now and then Save Austin Now's reports.
And whatever screenshots were offered during the discussion.
Yeah. Okay.
You mean the PowerPoint that I presented? Is that what you're asking? I'm sorry, I wasn't clear about what you wanted.
So just a quick friendly reminder, respectful reminder to parties. I appreciate the clarification question. I think she was referring to what Mr. Cascino was referring to, the screenshots that he had obtained. But I'll remind parties that unless we're at a phase of a proceeding where we're asking you questions, that it's out of order to speak. Unless we direct questions to you. But I appreciate it. I know that it was well-intentioned. Commissioner Stanton, yep.
Yes, I have a question about procedure.
Mm-hmm.
So this complaint alleges 3 violations, one of which does not have a date of alleged violation. Procedurally, are we voting to go to final hearing on only 2 of them? Can we vote to go to a hearing on all 3 of them if one of them does not have a date and that is in violation of our own code?
Sure. So I will answer this as quickly as I can, again, in the interest of time. So we've already voted to proceed to a final hearing. Because there are reasonable grounds to believe that a violation occurred. I think at the final hearing, we can discuss again, if respondent is so inclined to raise the argument again, that violation was improperly entered on the form or not properly brought before the commission because it violated our bylaws, which require that there be a time stamp, so to speak, that there be a date of when that violation occurred. And I think that it is fair game for respondents to raise that argument again, if they so choose. But the motion that prevailed was to go to a final hearing because a violation occurred, and at the final hearing we can, decide that, this actually isn't a really great grounds to determine that there was a violation. So we'll get rid of this one or that one. But
makes sense. Thank you.
Yeah, of course. We're talking about evidence. The last thing that I think I would be interested in seeing is just any additional information, if it's not too terribly long, I know these can be long, but the terms of service for GoFundMe, or at least maybe relevant provisions of the terms of service that might be helpful to us. If it turns out that the terms of service agreement, when you put it in a PDF, is 100 pages long, that might be excessive, but maybe just to make a good faith effort to identify relevant parts of the terms of service agreement as to what, because the point was raised that it was personal property of Mr. Swingler, and that's part of the terms of service is that it is the personal property of the person who sets up the donation or who is the recipient designated in the fundraising campaign. And that would be useful to have things like that in the terms of service agreement, I think. So Commissioner Danberg, go ahead.
Just a brief reminder that, of course, the burden is on the complainant.
Yep.
But I want to express my gratitude, not just to this complainant, but to future ones. I believe Mr. Swingler did all that he could figure out to do But we do, as Ms. Greenberg mentioned, we do have people who know better and who would try to use this channel. And so complainants like Mr. Cascino are doing all of us a favor by holding people to account. And, you know, that is no reflection whatsoever on Mr. Swingler, but it's certainly a reflection on some things that could happen with much worse intent.
Sure. So a reminder that I want to kind of give one more call for any evidence the commissioners think is relevant or important to request of the parties now. Commissioner Teniyuka?
I know that you guys mentioned the GoFundMe already, but is there a way to obtain a receipt from the GoFundMe page, basically just saying, here's how much you received and this is how much we're giving you due to the fee?
I think
and that would be for Mr. Swingler to provide.
Sure. No, I think
is that all possible?
I think that is something we can fit into this request. I'm going to read what we have so far, and then we can talk about anything else we might want. So we have screenshots from Mr. Cascino. We have the Save Austin Now campaign finance report. We have a copy of the GoFundMe page if it's retrievable. We have the info provided to Save Austin Now, the spreadsheet of donors. We have any relevant terms of service provisions, or if it's not too long, the terms of service agreement itself for GoFundMe. And then we have a receipt for the GoFundMe transaction. So that is, and to clarify that one, Commissioner Teniyuka, are you referring to kind of the sort of like the deposit receipt where GoFundMe says, here's the money you raised, here it is for you? Like here, that one? Okay.
Yes.
Got it. So I'll call it the GoFundMe deposit receipt. Okay, Commissioner Stanton.
Yes, was a screenshot mentioned for the quote from Google where it states I have spent $10,000 of my own money on what's okay. Thank you.
I think it was encompassed in the screenshots that Mr. Cascino has.
Okay, great. I'd like to call that out specifically.
Sure.
Thank you.
Okay, so that is the list. Is there anything else, commissioners? So I think the last thing that I'll say, Lynn Carter, you have the camera on, which means you have something for me. What's going on?
Yes, a couple of items. One is that the parties are supposed to be given an opportunity to ask, to request witnesses and evidence if they want that. Two is that the commission will need to vote tonight or at a future meeting on what evidence to request.
Right. Thank you so much for that. I appreciate it. For the new commissioners and for parties that may not have been before the commission before, Lynn is my referee, and I always appreciate her jumping in. So with that, I will quickly go first to the complainant, if you are still with us.
Yeah, I'm with you.
Yep, there you are, Mr. Cascino. Thank you. So I'll pose to you the question, basically what Lynn Carter just mentioned. What evidence or witnesses would you like to see at a final hearing?
I mean, if it's amenable, I'd like some stuff from GoFundMe, some receipts, and if that's possible, and if it's amenable, maybe some bank statements proving, what Mr. Swingler spent or didn't.
Okay.
It's publicly available through Save Austin Now already, right?
So
help me understand if you're wanting something different than that.
Yeah, I mean, has that been reported is my question. And
it was reported back in April.
So
my amounts were reported in April, as I've stated numerous times in this call.
Let's direct comments and questions to commissioners and try not to have talk between the parties. If you feel a need to jump in, kind of ask first, is all I'm really asking.
Sure, no problem.
So,
what exactly am I being asked for? Though? Just that's not already available. Just I'm a little confused.
Sure. So, so Mr. Cascino had mentioned bank statements to kind of further prove up what's being claimed about the amounts that came from GoFundMe and the amounts that went to the Save Austin Now.
Yeah, that would clarify it and pretty much sum up what I mean. That would be the most definitive and probably, easiest result in the most centralized place where we could find that. But that's my opinion, and if that's amenable, that's what I would appreciate.
Sure.
I need to talk to my client, but as a ground rule, we're not going to be willing to disclose his personal finances of himself. So I want to make sure that everyone's clear that his family expenses are off limits. That
sure.
Anything would be redacted if indeed he chooses to disclose that.
I would never ask for anything deeply personal.
Sure. Okay. All right. And now, Respondent, is there anything that you specifically want to request in terms of witnesses or evidence, or are there any specific kind of are there any concerns that you have about what's been discussed so far? You heard you kind of discuss bank statements and wanting to make sure that that was limited and redacted only to those items that were specifically relevant, but I want to give you the kind of full opportunity to, and I can run through what we've discussed so far again, if you'd like.
I took notes. I took notes.
No additional time needed on my behalf. No questions.
Okay.
No, nothing asked for whatsoever. We can just do another call, I guess.
Yeah, we made our disclosure earlier, and so we're that's that. Yeah, we're not going to ask for any other evidence from the complainant.
Sure. Or if there were anything about what we've already kind of identified as things that are going to be produced potentially, if so, for example, receipts of the deposits from the GoFundMe. I think I'm kind of beating a dead horse at this point, but
whatever's possible to get, we will. I mean, I don't know.
Would this not be on Joe to go dig up all this info?
Yeah, he has.
I haven't done anything wrong. I can't believe I'm spending my 11th hour on the subject. But is this not on Joe to prove I actually did something wrong before I go spend more hours of Eric and myself to I don't quite understand the process, but I would assume this would be on Joe to gather all this info.
Well, so there are some things that a complainant, with all due respect, there's some things that a complainant in any complaint simply does not have access to. If you kind of imagine a lawsuit, right? You would sue, like say you got in an accident with an 18-wheeler. You sue the company with the 18-wheeler saying, like, this guy, I think he was texting, but I need cell phone records. And I think he was asleep, or had zero sleep, and I'm going to need like logs. Things that you don't have access to. So I think these are things, unless Mr. Cascino does have access to some of these things, then that's kind of why we're here and having this discussion.
I'd like to chime in on this a little bit, because, Mr. Chairman, you make an analogy to what I do for a living. I sue people over car wrecks.
Yeah, go ahead.
If I come in with an allegation as thin as this, I'm not getting that information. This is a blank check to political opponents to snoop around in bank statements. And I, Mr. Cascino, I appreciate you saying that you don't want all of his personal expenses. But respectfully, you're not entitled to know what bank he uses. You're not entitled to know the routing number. You're not entitled to know anything except whether he gave a donation that came from money collected through GoFundMe to Save Austin Now. So I would suggest that the only thing that Mr. Swingler should be required to provide is evidence of that. whether it's I don't know if it was done by wire transfer or Venmo or I don't know what it could be. That's the only thing he should have to show. And then if there's this is another reason why this is, I so strenuously object. I know I lost the vote, but to proceeding on this, there's nothing to indicate that a direct expenditure was made. But since we're going to a final hearing, I think we should require Mr. Swingler to provide any receipts of direct campaign expenditures that he made, which presumably is going to be nothing. But opening this up to let somebody fish around in their political opponent's financial life is a can of worms I don't think this commission wants to get into. And I think this needs to be very limited to the very targeted things that he's alleged, which don't even amount to violations of the code.
Sure. Well, I do think it's reasonable to kind of take the bank statements off of the list of evidence. I think that's perfectly fair. I do think it's sufficient if we have like an email from GoFundMe that says, here's the amount of money you raised and here's what's getting deposited. And we have other confirmation of the contribution of that amount to Save Austin Now.
But that's already publicly available, and it has been for months. Like my Save Austin Now donations were available 2 months ago. When I made the...
So the things like the amended complaint, or not the amended complaint, I'm sorry, the amended financial disclosure that has the individual donors that I think did we not determine that was not publicly available yet, or is going to be available?
Yeah, and I think Eric stated that wasn't even required. We just did that as a good faith effort, like because I ended up, spending 5 hours on the last Zoom call. We decided, hey, like let's go ahead and since we didn't get to my section, we're like, hey, like let's go ahead and send these names just so that in case they want them, they can have them.
Sure.
They weren't the ones who made the donation to Save Austin Now, so we didn't even know whether we really needed to disclose that. We're just trying to kind of go above and beyond to hopefully the goal of that was to ensure that we didn't have to continue this.
Right.
So just to be clear, Mr. Chairman, that's publicly available information that really is the burden of the complainant to provide. I mean, if the complainant can't obtain it, I'm sure that somewhat, we can download this on the city's website or the Ethics Commission website. But I have to agree, same thing with the terms and conditions of the GoFundMe page. I mean, all of that's public. It's out there. My presentation was collected from the GoFundMe website, right? So the burden of proof is really on the complainant. And so I have to say that, we've expended a considerable amount of time, effort, and money defending against the complaint. And,
I just feel like
it's relevant. I have to agree with Commissioner Lovins. We'll look and see if there is something relevant, but, that's...
Sure. And I want to back up and just say that the purpose of this kind of part of the hearing is to have an open discussion about what we are going to vote on to ask the parties to bring to a final hearing. And so this open discussion that we're having right now is exactly what I'm hoping for, like conversations about who should produce what. I have no personal stake in who produces what. I think you raise a very good point about the burden being on the complainant. So anything that the complainant can get on their own and bring, then they should be required to do that. I think that's a really good point. So the one thing that I will point out is that the complainant would not have access to, I think, a receipt, some kind of email confirmation from GoFundMe that this amount was collected and deposited or transmitted to Mr. Swingler. So that is something that I think the respondent would have to show or have to provide, since that's something that physically Mr. Cascino does not have access to the respondent's email. So that's one thing. I think that the complainant is sophisticated enough to find the appropriate campaign finance reports. I think that the specific spreadsheet of donors that was given to the Political Action Committee, that is something that you guys have that the respondent does not have, or the complainant, does not have. So that's something that I think would be fair to ask respondents to produce screenshots, complainant, a cached copy of the GoFundMe page. I think it's fair to respectfully ask both parties to try to find it if they can, because I personally don't know how you go about finding a cached version of the GoFundMe page as it existed. It may require that the person who set up the GoFundMe page ask GoFundMe for that. And if GoFundMe still has it, like call customer service, or I don't know how GoFundMe works. So just a good faith effort on the part of both parties to try to find that. And I think that's fair. And then lastly, the terms of service agreement, I agree, publicly available. I think Mr. Cascino, as the complainant, should be responsible for sorting through that to find what he thinks are the relevant provisions. And then respondent, as always, is welcome to point out those provisions that they might think work in their favor, right? Does that all sound good?
Sounds fine to me.
Okay. I'm seeing an A-OK sign from Commissioner Danberg. It is 10:41. I try my best to be first deferential to the parties to say their piece, then deferential to commissioners to ask all the questions they want and say whatever they want. I know it takes a long time, but I think that this is how we get to fair process results. So with that, the motion that I'm about to say, just in the interest of time, I also like letting commissioners make the motions themselves. I don't like running the show. But the motion I'm going to make is kind of what I described, that complainant provide the screenshots that he described, the campaign finance reports that are relevant, right? The relevant terms of service agreements on the GoFundMe page that might be important to back up his complaint. And then for him to make a good faith effort to find a cached or a historical copy of the GoFundMe pages that existed while it was live and receiving donations. And then the second part for respondent to provide the spreadsheet, the information about the donors that was given to Save Austin Now as it was given to Save Austin Now. And then any kind of receipt or email confirmation from GoFundMe saying that this is the amount we are giving to you as a result of your fundraising campaign. That is my motion. Do I have a second?
I'll second.
Thank you, Commissioner Levins. Second from Commissioner Levins. We'll do a quick roll call, same as we've been doing all night long. I will say your name. Please unmute yourself, clearly say your vote. I'll confirm your vote back to you. Ready? Okay. Chair Sobran votes aye. Vice Chair Hurry is absent. Secretary Lerner.
Aye.
Secretary Lerner votes aye. Commissioner Danberg.
Aye.
Commissioner Danberg votes aye. Commissioner Greenberg.
Aye.
Commissioner Greenberg votes aye. Commissioner Kale.
Aye.
Commissioner Kale votes aye. Commissioner Laurie is absent. Commissioner Levins.
Aye.
Commissioner Levins votes aye. Commissioner McCormick.
Aye.
Commissioner McCormick votes aye. Commissioner Stanton.
Yes or aye.
Commissioner Stanton votes yes or aye. Commissioner Tanayuka.
Aye.
Commissioner Tanayuka votes aye. That is a unanimous motion. It passes. I want to thank the parties. I cannot thank you guys enough for your patience, not just in this hearing, but in the last hearing. And appreciate you working with us and looking forward to seeing you soon. Thank you again. Yes.
Mr. Chairman, your rules require you to set a date for production, and I didn't hear that.
Well, thank you for reminding me about the rules. Let us see. The normal... How about this? The normal production date is... you know what? In setting in the motion for the final hearing, there also should have been like a date set, I believe. Lynn Carter, are you around, my referee?
Yes, I'm around. I mean, the date is usually set in the final hearing notice, but it is the commission can always vote to set deadlines for production as well as production of exhibits. So it's up to you. I mean, typically we asked for the production at least 2 days before the deadline for exhibits. The exhibits we asked for one week prior to the hearing. The parties can always agree to, extend that time or postpone a motion. And
I want to make clear to the parties as well that, while in the past, the way we've treated those production deadlines as kind of requests, I am actually struggling to recall setting deadlines in motions on the part of the whole commission, with like one notable exception earlier this year. Because if the deadline in the notice of the final hearing isn't complied with, it's up to the commission as to whether or not they're going to put how much weight they're going to put on that evidence, right? Like you can still, there's no bar on offering up evidence as long as you make the effort to produce it by that time, and you don't like show up at the hearing with, by the way, I didn't tell you what was going to happen, but I've got 70 pages of documents that completely prove my case. So I don't think we need to set a deadline, a production deadline in this meeting, in this hearing on this specific complaint, if that's okay. If you prefer a hard and fast deadline for the commission to set with less flexibility, we can do that. But I think it would deviate from our practice. Okay.
Chair.
Yes.
Chair, I'm sorry. I don't understand that last. Are you saying that we don't need to set a deadline?
We don't historically set a deadline because the final hearing notice that will go to the parties when a final hearing is set, which is typically the next meeting. So if we have a meeting in July, it would likely be set for that meeting in July unless there were scheduling conflicts, or in August. The notice that goes out, the letter that goes to the parties, has in there kind of a production deadline. And the way we've treated it in the past is please produce evidence by the state. And then if evidence comes like a little bit later than that, through no fault of the parties, we give appropriate weight to that evidence as we have time to review it. So that is how we don't have to set a date right now for production by motion. Commissioner Danberg.
I think at this point, we have good reason to believe that we have good faith complainant and respondent.
Right.
So some of our horror stories from the past do not apply to these guys at this point in time. I think they're doing their best.
Right. Sure. I mean, if the need arises at a future meeting, if we set a final hearing and there's some huge, upturning of the apple cart and there's no evidence, then we evaluate it as it happens. And that's in setting the final hearing is typically a chair decision that I try to do in coordination and with the cooperation of both parties. So I will look forward to that cooperation and that good faith effort. And with that, I will excuse the parties, thank them profusely for their patience and for being here and for participating. And we will see you soon. Thank you, guys.
Mr. Chair, take care.
Okay. Commissioners, we are moving on at 10:49 p.m. to a final hearing. Here's what I'm going to say before we get into the final hearing. First, I'm going to confirm that our parties are here. We have complainant Mark Littlefield. Are you with us? Might give him a second since we're taking a hard turn from one complaint to another. I'm trying to be, I really do try to operate efficiently, but efficiency and deliberative process are not. There I see Mr. Littlefield. I'm here. Hello, sir. And I see counsel for respondent, Ms. Davidson. Hello.
Hello.
I thank you both for your patience this evening and waiting your turn, and thank you for your patience in the May meeting as well, and appreciate it. I see Commissioner Danberg. Oh, I also see, I think, Mr. Gober, are you representing the respondent as well?
I am.
Okay, well, welcome, Mr. Gober, to the Ethics Review Commission. I apologize that your first introduction was a postponement. Commissioner Danberg, I see your hand up.
Mr. Chairman, I'm having a physical issue and I need to ask to be excused, please.
Okay, then you are excused. And thank you for being here, and we will see you next time. Okay. All right, Commissioner Greenberg.
Maybe we should take a vote on the jurisdictional issue because that might only take 2 minutes rather than waiting.
Well, so I think we have the...
I always think things take less time than they do.
Oh, me too, trust me. So I think since we have the parties here, and since I think the parties have something to say about very recent developments, I think it's in our interest to kind of
listen.
Yeah, to take care of this, because if the jurisdictional issue is indeed a quick one, then I think we can dispose of it quickly without letting the parties wait any longer. So, okay, Commissioner Stanton.
Yes, a procedural question.
Mm-hmm.
Do we still have quorum to continue?
We do.
Or is okay? All right.
We do.
Thank
I believe
you.
we have 8 commissioners still present. 1, 2, 3, 4, 5, 6, 7. 7. Is that right? 1, 2, 3, 4, 5, 6, 7.
Did you count yourself?
I think I did. Did I not?
Can someone?
Anyway, I'm confident that we have 6, 7,
okay.
or 8, and 6 is quorum. So,
Okay, gotcha.
I'm not going to try to count again. So we, what we're going to do is, so we are agendized to have discussion and possible action regarding a final hearing. And before we jump into the final hearing, what I would like to do, and Lynn can referee me if this is not in order, or Steve, you can referee me if this is not in order since you're our outside counsel on this matter. I would like to give both parties 3 minutes to explain the kind of most recent development before we go through with a full final hearing, which is 10-minute presentations on both sides, and then a Q&A period, and then our typical motions and discussions section. Is that, first, outside counsel, is that appropriate? And then to commissioners, is that fine with you? And then I'd like a nod from the parties if that's okay with them as well. But,
yes, I think it's absolutely appropriate, and I think that the parties have something that they would like to announce to the commissioners.
Okay, so with that, I